You want me to get your screen on again, Ms. Brown? Okay. Right, so like you can probably it's a different meeting number if you get into Zoom. All right, here's the. Oh. All right, you ready? Okay. Good morning, everyone. It is a little after 9 on Wednesday, the 21st, and we are back with Jame Daniels versus MARTA. Mr. Johnson, are you all ready to go with whatever's coming next?
We are, thank you, Judge.
All right, Ms. Arnold, are you ready to go? Okay, I shared with both sides a final jury charge that reflects the edits that we made late yesterday during the charge conference. I also shared a verdict form that needs to work its way back to me in the end. Were there any objections, Mr. Dial, to the proposed verdict form?
No, Your Honor.
Okay, Mr. Johnson, any issues with the verdict form?
No, Your Honor.
Anyone know where it is?
Mr. Johnson.
All right, so give it to Deputy Gordon. I will take it back. Hopefully no one spilled coffee on it. All right. Ms. Arnold, when we bring the jurors in, the next step is for me to ask you if you're going to be calling any witnesses. What's your answer to that question?
We will not.
Okay, so you'll rest. And that means then I'll explain to the jurors that the evidence is closed and we're going to shift to closings. And pursuant to 910-186, I believe that MARTA has the opportunity to open and close. You hinted at that yesterday, Ms. Arnold. I assume your side intends to, in fact, open and close, or are you going to just reserve everything to have the final word?
Your Honor, we do intend to open and close.
Okay, great. And do you have set up what you need set up to get into that?
Yes, as long as Dan is on the system. Good.
All right, Dan is on. Mr. Johnson, anything we need to take up from plaintiff's side before I bring the jurors in?
I don't believe so, Your Honor. Thank you.
Great. All right, excellent. Well, then let's bring them in. Thanks.
All right, observe. Present.
Thank you, Deputy Gordon. Everyone can be seated. Welcome back, my friends, for your third day of jury service. It's Wednesday, the 21st. I think we're on the cusp of fall starting. I think maybe tomorrow is the autumnal equinox. We closed yesterday with the plaintiff resting. So what is next is for the defense to put on any evidence if they want to. I'll remind you that the defense, MARTA, does not have the burden of proof here. It's Ms. Daniels and her legal team that has the burden of proof of showing what amount of damages is appropriate in this situation. So I'm going to turn now to Ms. Arnold to ask if MARTA is putting on any witnesses.
We will not be holding witnesses.
Okay.
Rest.
Okay, so both parties have rested, which means the evidence is closed. You have heard and seen, and you'll get the documents that were admitted, received, all the evidence that you may consider during your deliberations. There are 2 steps left before you can start those deliberations. First will be closing arguments from the lawyers. And as I told you at the outset of the trial, this is the opportunity for the lawyers to argue to you what they think the evidence has shown or failed to show. The lawyers will attempt to persuade you to view the case the way they view the case, and that's perfectly appropriate. But do recall that what the lawyers say is not evidence. Evidence is what you remember the testimony to be, and obviously what these documents say or depict that you'll receive during your deliberations. When the lawyers are done with closing arguments, I will share with you this, which is the jury charge, the law that you must apply to the facts as you find them to be. Once I've given you that jury charge, we get you back there in your favorite room, get the evidence back to you, the jury charge, the verdict form, and you'll be able to begin your deliberations. With closing arguments, if the defense puts on no evidence, meaning calls no witnesses, then they have the opportunity to open and close with closings, and that's what they've elected to do. So you will hear from one of MARTA's attorneys in just a moment. At some point, that lawyer will sit down, and then Mr. Johnson will have the opportunity to make his entire closing. When he's done, then a lawyer, it may be the same one from MARTA, will have the last word in terms of closing arguments. We will take a morning break, I promise. We probably can't fit all the things I described in before that morning break. We will not interrupt a closing, but it may be that after one of the closings, but before you've heard everything, we take our morning break. All right. With that, Ms. Arnold or colleague.
Thank you, Your Honor. Turn this back around here. Do this now, so I don't have to interrupt. I don't want to block you, Judge. Is this gonna be okay if I put this right here?
I'll be strong.
Hang tight, hang tight.
Yep. Can I see that just before you put it up?
It's,
Okay, it's words.
It's
That's
words,
fine.
it's what I put.
All right. That might be a
Key
cool picture.
points, if anyone remembered what I said on Monday. Okay, good morning, guys. I want to start where I finished in opening statements, which was talking about the one question you're here to answer. What is fair and reasonable compensation for Ms. Daniels? You've now heard all the evidence, and I hope that you've kept in mind the 3 key points that we talked about in opening statements, because those are the 3 key points that you will need to decide this case. So let's talk about how the evidence came in to support these 3 points. But as we do, I want you to consider one of the charges that the judge is going to give you. Let's see. Okay.
This is your equipment, I hope, that isn't working. All right, not counting.
Not blaming you.
All right, good.
The judge is going to instruct you on the credibility of witnesses, because you must judge the credibility of the witnesses who have testified in this case. In doing so, you can consider the witness's manner of testifying. You can consider the probability or the improbability of their testimony. You can consider their interest or their lack of interest in the outcome of this lawsuit. You can also consider evidence attacking that witness's credibility. Credibility may be attacked by disproving facts that the witness has testified about. So as we talk back through the witnesses who have testified in this case, be thinking about that. And the judge is going to instruct you at the end of closings, so you keep that in mind as you're considering the evidence in this case. So who's the first witness that Mr. Johnson chose to call in this case? He chose to call the plaintiff's former boss to come in here and tell you that she's not qualified to do the job that she used to do before this accident. And you know what? We don't disagree with that. Right now, I know that she can't go back and do this job. Our focus is on what she's going to be able to do in the future when she recovers from this ankle surgery and this knee surgery that are intended to eliminate the pain in her lower extremities. Now, there's other evidence in the case to suggest that she could be working in some other capacity in the past 2.5 years since this accident. But all Ms. Poole offers is that she can't come back and do this job now. And on cross-examination, we had to elicit testimony that if Ms. Daniels was able to perform her job duties and a position were available, she would rehire her. She was an excellent employee. So if there was a position and she could do the job, she would rehire her. We had to elicit that testimony from this witness. So who did plaintiff choose to call next? One of her paid experts. And what information does this expert have to assist you as the triers of fact? Well, not much, because he only saw Ms. Daniels for 5 hours on one day in August in 2021. That's over a year ago. And he admitted under cross-examination that during those 5 hours on that one day in August of 2001, he didn't ask her anything about what her life was like outside the 5 hours that he spent with her. He didn't know what she was doing on a daily basis. He didn't know what her family life involved. He didn't know that she was capable of airplane travel. He didn't know that she was taking her daughter to work every day, round trip over an hour. He didn't know that she was taking her daughter to school every day, round trip an hour. I bet you didn't know about that TikTok post she made 5 days before her exam. That's information that the doctors consider relevant when determining if someone's able to work. And what's his opinion? That she can't work. That she's incapable of any form of employment as a result of this accident. And his opinion is limited to those 5 hours on that one day in August of 2021. He can't say as of today that she's unable to work in any capacity. He can't say in the future, after she has these 2 surgeries, that she's unable to work in any capacity. The only evidence and information he brings to assist you is how she performed on that one day for those 5 hours in August of last year. So who did plaintiff choose to call next in her case in chief? Another paid expert. And this expert changed his opinion right before trial because the plaintiff has now completely disregarded the option where she never returns to work. That was his opinion before. Now his opinion is that's no longer defensible. She's absolutely going to go back to work in some form in September of 2023. His opinion is that that's got to be a sedentary position. And he picks 3 jobs out of thin air. He bases them on job duties she has had in the past. He doesn't base them on jobs she's actually worked in the past. He doesn't base them on a qualified vocational rehabilitation opinion as to what she may be qualified to do. But he picks these 3 jobs, and he picks 3 out of hundreds and hundreds of jobs that she would potentially be qualified for. Probably because he picked the 3 lowest salaries of that entire category of jobs. So he uses that for his analysis. But he does say, if she's able to go back to her old job, then her lost earnings drop to 0. You heard him talk on direct and on cross about the fact that he thinks she's qualified to go back as a nursing aide. And anybody who knows a nursing aide or an orderly knows that those people are on there. That is a heavy labor-intensive job. You are on your feet all day. You are transferring patients. You are pushing the wheelchair. If she can do that, why can't she do her old job? Why didn't he value that? He also gives a maximum household services loss of $45,000 because he says, you know what? Regardless of whether she goes back to work, that terminates in September of 2023. That number cannot get higher than $45,000. It can be less if you think that she didn't need the help, but it can't be more. He also gives a maximum past lost wages scenario, which assumes she has not been able to work from the date of the accident all the way to September of 2023. That's what that number is. So if you find, as the triers of fact, that she has been able to work in some capacity since the accident, that number will be less. That's the highest it can be for past loss earnings, if you believe this paid expert. So who did plaintiff call next? Family member, daughter, Miss Sermons. And what did we learn from Miss Sermons? We learned that Miss Daniels drove her to and work for several months through Atlanta traffic, trying to get to Lenox Square Mall, which can be a nightmare, on a daily basis. We learned that she's traveled with her mom multiple times, that her mom was able to take her to Vegas for her birthday. And you know what? That's great. These are things that Miss Daniels should be doing. These are things we want her to be doing. These are things we're glad she's still able to do. And we heard about that from her daughter, that she's able to have these shared experiences with her mom. Then we started hearing from the doctors. And you heard from Diane Payne first. She's the upper extremity doctor. She's the wrist doctor. And she was emphatic about the need for Miss Daniels to work with a certified hand therapist when she left to go to Texas to ensure that she was able to recover and obtain normal function in her wrist. And she was very specific in her deposition about certain exercises with the hand and the wrist that she should be doing with this certified hand therapist while she was in Texas. And she was very specific about the recommendation to have that therapy for at least 3 to 6 months. She also testified that when Miss Daniels moved back to Atlanta and she saw one of Dr. Payne's partners, Ms. Daniels elected to not pursue any further treatment of the wrist. Then we heard from mom. And Miss Lundy saw her daughter at her worst. She invited her into her home to care for her as any mother would following this. Invited Miss Daniels' ex-boyfriend into her home to help care for Miss Daniels during that time when she was at her worst. But she didn't live with Miss Daniels when she was at her best after this accident, when she was living independently, when she was driving again, when she was able to perform activities of daily living again. So she can't offer testimony about what it was like to live with Miss Daniels during those times. She also testified that her daughter loved her job. She was a hard worker with good work ethic. And that's important because it plays into what you need to consider when determining her ability and her motivation to go back to work. She talked about the things they do to keep Miss Daniels active, going out to eat, doing things with the family. This is the testimony that you heard from the mother. So then we heard more testimony from the doctors. And I won't spend too much time on it because, like I told you in opening, we don't contest the past meds. We're not fighting over the medical treatment that she's received and that she intends to receive. So there are some important points that these doctors make. Dr. Moore agreed physical therapy and home exercise program, not the best thing for, are important for healing. He recommended follow up with an orthopedic when he moved to Texas. Nothing in the records says that she's unable to work. And Dr. Moore has seen her since day one, up until he referred her out to Dr. Kadakia and Dr. Sadlak for this current future treatment. Dr. Moore, contrary to Mr. Yeager, the paid expert in this case, would want to consider what Miss Daniels is doing on a daily basis. He would want to know that information before he gives an opinion about whether she's able to work. The medical doctor, the treating physician said that. He wasn't provided a copy of Mr. Yeager's report. He's not able to say whether or not the recommendations in the report are consistent with his opinions as the treating physician, the one who's treating Miss Daniels, who's a medical doctor. He wasn't provided that opportunity. And he says these recent and future surgeries will remove the pain generator from the knee and the ankle. And that's important. Dr. Kadakia, the new recent foot doctor, the one that just performed the surgery in June. He also agrees the purpose of physical therapy and home exercise programs is to improve gait and functioning as well as strength. Can't stress that enough. All of these doctors, he too would want to consider Miss Daniels' activities of daily living before he would give an opinion about whether she's able to work. With respect to the fusion, yes, she has some limited range of motion, but he talked to you about most people don't have much range of motion in that part of their heel anyways. So it's not going to restrict her any more than she already is, but it's going to eliminate that pain. And she can still be quite active. And if it's successful, there's not going to be any pain in that joint, and she can get back into normal shoes. And that's important for her, as you saw. Dr. Sadlak, the last doctor, who I'm sure you were happy about, since that wasn't the most exciting witness, agrees. Physical therapy, important to get back strength and range of motion. He too would want to consider activities of daily living before giving an opinion about whether she's able to work. He too was not provided the opportunity to review the functional capacity evaluation or the impairment rating that the paid expert did. Even though, when I deposed him the first time, he said he'd like to see it. but he wasn't given the opportunity when we deposed him the second time for trial. Surgery is gonna fix that deformity in her knee, that valgus alignment. The surgery that she's expected to have will fix that. The goal of the surgery is to alleviate pain and maintain range of motion in the knee. The fusion limits it some in her ankle, but this is not gonna limit any range of motion in her knee, and it'll eliminate pain. And he says, sit, stand, walk without pain, that's the goal. Ms. Daniels was the last witness that you heard from, and that was very recent, just yesterday afternoon, but what did she have to say? She's independent with activities of daily living and driving. She still enjoys going to the hair salon, getting her nails done, shopping, dining out, time with friends and family. As she should, as we want her to do. Travels since the accident, Chicago, Minnesota, Texas, New Orleans, San Diego, Charlotte, Las Vegas. Good for her. Good for her that she's able to do those things since this accident. We are happy that she's able to get out and do this. And she's going to weddings, and she's celebrating birthdays, and she's going to graduations, and she's going to football games, and she's going to Bourbon Street. And she didn't dispute any of that. Good for her. Now, one thing I know that Mr. Johnson's going to point out is that we didn't call Peggy Freeman. You've heard about Peggy Freeman. You know that she's MARTA's expert in this case, but we didn't call her. Now, do you remember in opening when I told you that because I go second, if I think you've heard all the evidence you need to hear in this case, then I'm not going to waste anybody's time by putting up additional evidence that's unnecessary. And there's no reason to put Ms. Friedman up in this case because you know what her opinion is. It's the opposite of Mark Yeager's. And she evaluated Ms. Daniels in November of 2021 and determined that she was capable of sedentary employment. And we know that because Dr. Seaman relies on that. But just like Mr. Yeager, her opinion is limited because she hasn't evaluated her again since this most recent surgery. And she hasn't evaluated her after she has this knee surgery. So she's limited just like Mark Yeager. So she doesn't have much to offer you to assist you as the trier of fact. So we didn't call her. And as you heard the judge say, we don't have the burden of proof. We didn't have to call her. I didn't want to call her just to get up here and tell you that. So now that we recapped the evidence, I want to come back to our 3 key points that should guide you in your decision-making process, right? That we've kept in mind the whole time. She's independent in ADLs. She can do many of the activities she enjoyed before the accident. The goal of these surgeries is to eliminate the current pain she experiences while sitting, standing, and walking. And she's going to go back to some form of employment in September of 2023. These are positive things. And we had to elicit a lot of that from some of these witnesses that were put up in the plaintiff's case. These are positive aspects in her life. Things that we can focus on for a bright future. So what is fair and reasonable compensation for Ms. Daniels? Well, as the judge told you, I get the benefit of having the last word in this case. So I'm gonna come back up here after Mr. Johnson, and I'm gonna tell you what we believe is fair and reasonable compensation for Ms. Daniels. And I can assure you that that number will be fair and reasonable and grounded in the evidence. And when Mr. Johnson stands up to tell you what he thinks should be the compensation for Ms. Daniels, I want you to ask yourself, is this fair and reasonable and grounded in the evidence? Because I think Mr. Johnson's going to come up here and give you a number that is none of those things. I think he's going to come up here and give you a number that is far beyond a number that is fair and reasonable and grounded in the evidence. And I think he's going to come up here and ask you for $5 or $6 million. He may base that on things that have nothing to do with the facts in this case. Like how much professional athletes get paid. Or how much some people pay for expensive art. He may double that number in the hopes that you split the baby and give him half of what he asked for. I don't know what he's going to say to you, but I'm going to let him do that. And then I'm going to come back and we're going to talk about what's fair and reasonable compensation for Ms. Daniels. Thank you very much.
Would you like Ms. Arnold to take away the easel or leave the easel, but just the board?
Leave the easel, we'll move the board, and I'll put something else up.
Substitute board. Excellent. Can I see, is it the body diagram?
It is.
Okay.
Good morning. On behalf of myself and Ms. Sadler and Ms. Daniels, we really appreciate you taking your time to listen to this evidence, and I realize it's an inconvenience out of your lives, and without you, Ms. Daniels would have no opportunity to ask her what she's owed, and we really, appreciate that you all are note takers, and I hope as I talk, those of you who really like taking notes will take notes, because I can't send back with you the figures that I'm going to give you during this closing argument. I heard Ms. Arnold say something in the opening statements, if you'll think back. She said, at the end of this case, something to the effect of, at the end of this case, MARTA's going to propose a number that will make a real difference in Ms. Daniels' life and the lives of her family. Do you remember that? It'll make a real difference. And that got me thinking, what does that have to do with anything? What does making a real difference in her life have to do with anything? It doesn't equate to any kind of measure of damages. And I thought, well, why would she say that? Why would she make that point that the money, whatever it is that MARTA suggests, will make a real difference in her life? I think the reason that MARTA wants you to think that way is because it takes less money to make a real difference in somebody's life if they're poor, right? It takes less money. If she were rich, it would take, I suppose, under that theory, a great deal more money to make a real difference in her life. But that's not fair. Her damages are her damages. Doesn't matter whether she's rich or she's poor. She suffered the same damages as anybody else suffered, and they're worth the same amount. And I want you to consider that as you listen to the way we see this case. I want to talk about a few misconceptions that I think, might be floating around this case before we get into numbers. And the first of those is this, sympathy, the notion of sympathy. Okay, are we asking for your sympathy? Are we asking you to feel sorry for Ms. Daniels? Well, I hope you don't feel that we are. I hope you don't feel that I've done anything to suggest that MARTA owes money or a certain amount of money because you all feel sorry for Ms. Daniels. We don't want sympathy. Ms. Daniels doesn't want sympathy. I think you can tell by listening to her on the stand, that's not really who she is. What she wants is fairness. What she wants is complete compensation. What she wants is not a discounted verdict. That's what she wants. Misconception number 2, we do not have to justify a few fun days in Miss Daniels' life in order to prove to you that she was catastrophically injured. We do not have to do that. The fact that Miss Arnold points out on behalf of MARTA that Miss Daniels gets her hair done and gets her nails done, her fingernails done on her scarred arms, and gets her toenails painted on her scarred legs. Took her son, before he ran out of money and had to leave, took her son to school, supported him, supported her daughter. These don't mean that she's not entitled to what she's owed for her injuries. Miss Daniels says we don't focus enough on the good things in Miss Daniels' life. And I got to tell you, I think that's probably right. Because I'm not here on behalf of Miss Daniels to ask you to make MARTA pay for the good things in Miss Daniels' life. That's not what we're here for. We're asking you to make MARTA pay for what they've done to make her life worse. And so that's the evidence we present. Because that's all we're asking for money for. The final misconception, and I think it's the worst, is that Miss Daniels isn't destined for a full recovery just because MARTA hopes so. And I'm going to talk about that because I think that's a huge issue here. You heard Ms. Arnold. It's a done deal in Ms. Arnold's mind. Miss Daniels is going to be great. Her future is rosy, right? Just take her word for it. Take MARTA's word for it. Well, if you're thinking about that and whether that's true, I just want you to ask yourself a couple of questions about that, okay? How's it gone so far for Miss Daniels with doctors curing her? How's it gone so far, right? This current surgery that she had that we don't know the outcome yet, and these future knee surgeries, they're going to make her all better, says Mark. But Dr. Moore operated on her leg and on her ankle. And if you'll bring up an exhibit for me, P11, I want to remind you that Dr. Moore, I'm sure, thought that his surgery was going to make her all better, right? And if this trial had taken place at this stage in her recovery from the first surgery, Miss Arnold would be up here telling you, hey, it's going to be great once she heals. Well, she's not healed yet, you know, but she will heal. And then she's going to be just fine, right? She'll be fine. Well, she wasn't. As she told you, and as you can see here, her right foot splays out to the right. And as the doctors told you, her right knee points inward. So, I mean, the notion that just because a doctor is going to perform a procedure, that everything's going to be okay is a fallacy. I mean, that proves it right there. If it were true that what a doctor did would guarantee a good outcome, Miss Daniels wouldn't be sitting here right now with a cast on her foot, having had an ankle fusion after the first surgery wasn't right. Would she have a wrist that's frozen in place if after 2 surgeries, right? Dr. P did 2 surgeries, did the initial surgery in the emergency room and then later removed some of the metal out of her wrist, if you'll remember that. So 2 wrist surgeries, and the result of that is she has no movement in her right wrist, okay? That's forever. Nobody's disputing that. MARTA's not disputing that. That's forever. If this trial had taken place while she was still healing from her first wrist surgery, what would MARTA have said about her wrist? You want to guess? It's going to be great. Dr. Payne's a great doctor. She's gonna heal just fine. She's gonna have her wrist back. That's what we would have heard from Marta. If you think I'm wrong, tell me. Tell me what your verdict. If you think I'm wrong. If you think that's not what Marta would say, if we were here right after that first wrist surgery. Of course, that's what they said. Everything's gonna be all right. Just ask Marta. Also, when thinking about whether everything is going to be all right, let's just remember a little bit of testimony from the doctors. Dr. Kadakia, who did the ankle fusion surgery, said it'll take 6 to 9 months before he knows whether there will be a non-union of the bones that he attempted to fuse. Even he doesn't know whether the surgery was successful. He can't know yet. And you know what else he said that didn't occur to me, quite frankly, until I rewatched the video with you all. He said that he plans on seeing Miss Daniels once a year for the rest of her life. Remember that? Go see her once a year for the rest of her life. Why would that be? Everything's going to be fine after 6 or 9 months. Just ask Marta. But the doctor says he needs to see her once a year forever. What does that tell you about whether this is a miracle cure that sure takes away, motion in her ankle, but no big deal, says Marta. You don't move your ankle that much anyway if you step on an uneven surface. What does that tell you about the likelihood, the obviousness that all is going to be fine with her ankle? It's a myth. Let's talk about the knee. Miss Daniel says, she's gonna have a knee surgery. She's gonna have a new knee. It's gonna be great. Her right foot's not gonna be pointed out to the right. Her right knee's not gonna be pointed inward. She's not gonna be in horrible pain all day like she has been. Her leg's not gonna swell up every day like it has, right? It's all gonna be great. But Dr. Sadlak said that 20% of knee replacement patients aren't completely satisfied with the outcome of their knee surgery. 20%. And by the way, even if, the 6th or 7th time's the charm with surgeries, and she's got a leg like the bionic man, or woman, I guess, in this case, she's going to have the scars that she shows you for the rest of her life, right? She's going to have an unusable, unmovable right wrist for the rest of her life. She's going to have a fused ankle for the rest of her life. Marta wants you to look past that. But we'll talk about that, and we're going to tell you what we think those things are worth. But the fundamental point is here that you all need to decide who bears the risk of the future. Is it fair for Marta to injure someone like Miss Daniels so badly that she can't come close to being completely healed by the time she's forced to go to trial, and then say, we don't really owe her anything in the future much because she'll, the outcome's uncertain and she'll probably be okay. Whose fault is it that I'm standing before you today 2.5 years after they crashed a MARTA bus into Miss Daniels head on? Whose fault is it that I'm standing here if we don't know whether Miss Daniels is going to be able to walk right again or is going to be in pain for the rest of her life? Is it my fault? Is it Miss Daniels' fault? They did it to her. She's had 6 or 7 surgeries, depending on how you count them by now. I think she's, been working pretty hard at surgically correcting what ails her. But Marta says, yes, she's going to be fine, and that if she's not fine, that Miss Daniels should bear that risk. Marta wants you to assume the very best for Miss Daniels. And they couch that in, oh, we all want what's best for Ms. Daniels, right? But why does MARTA want you to assume the very best for Ms. Daniels? Because they don't want to pay but a few $1 million to Ms. Daniels, and they're hoping that you think that's great. And by the way, and we're going to get to my numbers, but when Ms. Arnold said he may ask for as much as $5 million, she knows full well our number is vastly more than that, vastly more. And we will give you all of the math behind our numbers. But if you believe in miracles, if you believe that the 7th time's the charm, then Ms. Daniels is going to have a very good leg going forward with her fused ankle and her artificial knee. And look, let's also keep in mind, some of you guys are in great shape, great athletes. I mean, you can just look and tell you all. And you may think, you know, as somebody who's a great athlete, a good athlete, if I had a surgery to my leg or my knee, I could just tough it out, I could rehab it, and I'd be back, right? I'd be back. Athletes always are. Miss Daniels, if you'll take a look at her, and she knows I love her, but she's not an athlete. She's a 45-year-old woman that doesn't run marathons, that doesn't work out. She's not a fitness buff. That wasn't her life. That's the person, okay, that is going to have to recover from an ankle fusion and a knee replacement and to live the rest of her life without the use of her wrist. The next point I want to make is this notion of victim blaming. This is not right. Let me point a few things out to you. MARTA does not owe Ms. Daniels less money because Ms. Daniels is overweight and hasn't lost weight since they broke all of these bones in her body. Okay? That's not right. Ms. Arnold questioned the doctors about, well, has she lost any weight? You know, she's, says she's medically obese. Has she lost any weight? No. The other way they victim blame her is by saying she just didn't do enough to eat. She just didn't do enough. This is really it's her fault because she didn't do enough to get better. Sure, we crashed into her, we broke a bunch of bones and put a bunch of metal inside her, but really she hasn't worked hard enough. Well, I don't know what else to do to demonstrate that that's not right, other than to show you the videos that we had, and we didn't have very many, but we showed you the ones we did have, of how hard it was for her to be in this position that you find her in today. I mean, it was really hard. You saw the joy that my favorite video, and I showed it twice because it just means something to me, is the video of the first time she got out of bed at her mom's. Remember that? First time she got out of bed and into a wheelchair, and how excited she was about that. I mean, it was an accomplishment. It was a real accomplishment. And then, it was months before she could begin to try to learn how to walk. But once she did, you saw what she went through. You got just a little taste of it. You have to multiply that times a ton to get the full picture of it. But strapped her to a harness, okay? And she worked like hell to be able to walk again. I mean, you met her, you listened to her, you listened to her boss. Do you really think that this lady is a slacker? That she got crushed by a MARTA bus and said, "To heck with it, I'll just let it go." That's the beauty of getting to look at people who testify. Because you get to assess who they are as people, right? It's not, if that wasn't important, we could just read you testimony, right? But you got to listen to her and look at her. You got to listen to her boss. You got to listen to her mother. You think this isn't a hard worker? Really? She testified that she did every bit of physical therapy she thought she was instructed to do or could do. She did her best. And it's victim blaming to say otherwise. So my only point is this. Whatever you determine the value of her damages to be, whatever that is, don't blame her for any of it. The fact that Janice is a human being who did her best is enough if you crash into her with a MARTA bus. I want to say a word about wages. I told you in the beginning of the trial that the wage loss claim, future past, all of it, total compensation claim, would be the smallest part of her damages. Do you remember that? It says it would be the smallest part of her damages. But they are her damages. And so as her lawyer, I'm obligated to bring you evidence so she can get them, because she's not only entitled to the big things, she's entitled to the smaller things. She's entitled to everything. It's my job to see that she gets everything that she's entitled to. So we brought you evidence on wage loss, right? Dr. Seaman, who has worked for Miss Arnold's firm, told you about her prior wage loss and how he calculated it. And we'll go over those numbers a little bit later. But does anybody really think that Ms. Daniels could have done that property manager job between the date of loss and today? My understanding is Peggy Freeman was going to say she could, but MARTA changed his mind about that. We'll talk about Peggy Freeman in a minute. There's no dispute here, okay? I mean, I'm not going to dwell on this. She's owed every penny of what she lost from that job from the date she was hit by the MARTA bus until today, and for at least a year from now, at least a year. Could she have gotten another job, right? Between, not in the future, we'll talk about that, but between the date MARTA did this to her and today, does anybody here think that she could withstand, Ms. Daniels could withstand the rigors of a 40-hour work week? I'm not talking about a 2-day jaunt in a wheelchair in a scooter somewhere and then flying back. I'm talking about a 40-hour work week. You've listened to the evidence. I mean, the reason we have juries is you all can bring your sense of practicality and common sense to the equation. And I'm asking you, do you really think that Ms. Daniels has had the stamina for a 40-hour-a-week full-time job since this collision occurred? There's just no chance. Now, future economic losses. I want to talk about that because it's a little more complicated. They want to tell you, first of all, they have multiple arguments about why they shouldn't pay much, but their first argument on the future wage loss is, hey, remember, everything's going to be fine. Everything's going to be great. She's going to be a property manager again, just like she was before. I'm sure there's a lot of those jobs out there. You know, the one that she had before is not available anymore, by the way. You heard her boss say that. All those jobs have been filled, right? Those are gone. So, you know, but hey, she's going to be well enough. It's all going to go great for her. Do you guys really think, does anybody really think that with an artificial knee and a fused ankle on that woman, Miss Daniels, that she's gonna be able to take a job where she climbs up 4-story buildings? Does anybody really think that's probable? No, because no, you don't. Because even if she has, you know, a reasonably good result from these surgeries, that's not going to be her body, and we all know that, okay? So this notion that, oh, it's all gonna be fine. She'll be a property manager again in no time. Because these next surgeries, they're the ticket. That's not reasonable. And we know that's not reasonable. And that's why we brought you, Dr. C, to testify about, well, what if you got another job that didn't pay as much, but you didn't have to go up and down 4-story, buildings on stairs to do it? What if you did that? He told you what the average job pays at her level of education for light duty work. He did not say, and you just heard Ms. Arnold say that Dr. Seaman said she could be a nurse with all that heavy lifting. Remember when Ms. Arnold just said that? She could lift those bodies and move them. If she could do that, why can't she be a property manager? He didn't say she could do that. His point was, just because a job isn't light duty doesn't mean it pays more. That was his point. His point is, sure, I could have used I could have plugged in 31,000, which is what she did as a nurse. And by the way, he said, that's a hard job. She couldn't do that job. Nobody said she could do that job. The point is, just because a job is heavy lifting required, doesn't mean it pays more. That is his whole point. We gave you what we thought was a fair analysis of what she's going to lose in the future. And we're gonna be confident. I'm gonna give you the numbers in a little bit and we'll talk about it. And then you can make a decision and we'll be at peace with it. Like I say, I'm forced to spend a lot of time on this issue because it's a little bit complicated, but that's the only reason. But I want to ask you why you think MARTA spent so much time on it. MARTA devoted most of this trial not to what was it like to learn to walk again, what was it like to have somebody else have to help you go to the bathroom, what's it worth to hurt all the time. They didn't devote any significant time to those issues. Their whole focus here was, could you go back to work, right? Could you go back to work? Why do you think that is? Well, the answer is obvious. It's what magicians call misdirection, right? You spend all your time and focus on the small thing, and so that the jury doesn't notice the big thing right in front of them. That's why so much of the oxygen in this case was taken up by this issue of wage loss. Right? It's so you wouldn't think about the big stuff. But we're going to talk about the big stuff. Before we do, let me say a word about functional capacity evaluations. I feel like I need to. We brought you Mark Yeager to tell you what objective testing of her physical capabilities looked like, what it revealed. Now, the thing about functional capacity evaluations, as I think you've learned, is they don't take place over a 3 or 4 year period, right? You go and you have basically a full day of testing done. And then those test results reveal conclusions about what your limitations are, right? And that happened back last August. We could any date we chose for it was going to be a date in time, right? And so it's no criticism of it that it took place last August. That's when it took place. That's also when Ms. Friedman did the same thing. But I will tell you that nothing has changed for the better yet for Ms. Daniels since last August, has it? She's in a cast right now. Do you think if she redid the functional capacity evaluation today, she'd come out better than she did last August? She couldn't even do it now. She's in a cast. She was hurting so bad that she said to a doctor, "Fuse my ankle, please." Why didn't we share the functional capacity evaluation with her treating doctors? Let's talk about that. That was important, Ms. Arnold. She asked all the doctors that, if you remember. Here's the thing about that. The minute we involve Ms. Daniels treating doctors in our effort to prove our case, they become advocates, okay? They have skin in the game once we share functional capacity evaluations with them. All of a sudden, you don't look at them as they testify as just treating professional doctors, right? They're advocates now. And then Miss Arnold gets up and she says, see, Mr. Johnson got the doctors to go in on the functional capacity evaluation. You know, these doctors, you know, they're biased. They're not giving you the straight story. We wanted you, as silly as this may sound, we wanted you to hear what the doctors thought based on being doctors, okay? That's why we didn't suck them into this dispute that Ms. Arnold and I have been having about functional capacity evaluations, just so you know. Now, let's talk about Peggy Friedman for a minute. Ms. Arnold has come up with an excuse for why they put Ms. Daniels through a battery of tests. Had their paid expert, as Ms. Arnold likes to call these people, test her, write a report, read Mark Friedman's discovery deposition that he gave to Ms. Arnold before trial. And yet, they decided not to call her as a witness. Ms. Arnold has done her best to testify on Ms. Friedman's behalf, hasn't she? You've heard her tell you, right? This is what Ms. Friedman would say. This, you know. But do you really think, with all the effort MARTA has made to keep this verdict down, do you really think that if Ms. Friedman was on their side, if their expert would back up what they think, do you really think they wouldn't have called her? You think that they were just trying to save you time? Really? Is that what you think here? They're just trying to save you some time. Hey, we didn't want to trouble you, okay? We just didn't want to trouble you. What if Ms. Friedman had had a single criticism of what Mark Yeager did? She would have sat right there, taking an oath before God, and she would have told All right. I told you at the beginning of this case that we would not stand up here, throw out a large number and say, trust me, the evidence supports that. That's not right. That's not right for anybody. That's not our obligation. And if MARTA gives you a number, it's not their obligation. So I hope you'll forgive us, but we've done pretty much exactly the opposite of that. We have broken down her damages into as many different categories as seem fair to us. And we have assigned a separate value to each of those components of her claim. So if you like our numbers, you can use them for all these different components of her damages. If you don't like some components of her damages, you don't have to use those. And if you like different numbers, you can use those. But we wanted to show you what our methodology was. The first category, or what I told you, was the easy part of the case and the smallest part of the case. Medical bills and economic losses. And I, again, am so grateful that there are notepads, because you're gonna, if you're interested in what we have to say, notepads are gonna be very helpful to you here. Medical bills, $909,000. Lifetime economic losses, $916,000. That's comprised of $172,000. And even though I don't think it's fair, that we have to assume for you that Ms. Daniels goes back to work in here. I don't think that's fair, because we don't know, right? And the risk shouldn't be on Ms. Daniels that takes place, but we have to come up with some place. And we have to come up with some scenario. And so, assuming a really positive outcome, assuming she doesn't get in trouble with any of these surgeries, that nothing else goes wrong, and that she's able to return to work in about a year at more of a light duty job that pays less than being a property manager at a 20-acre, 210 unit apartment complex. Assuming that that goes that well for her, Dr. Seaman told you that her future losses for the rest of her working life would be about $700,000. And then total loss of household services about $46,000. If you add it all up, if you agree with us that this is the fairest scenario to Ms. Daniels, $916,000. Okay. That was the easy stuff. Here's the rest of the story. All other damages that MARTA must pay for. So let's talk about it. What do I mean by paying trauma from the crash? I mean that story that Ms. Daniels told you about sitting in a crushed car with 2 broken arms dangling down, a leg snapped in half, unable to move, frightened and unimaginable pain, and there was nothing she could do about it but just be there and live that until firefighters had to physically pull her out of the car. Okay? What's just that time, what is that worth for what she went through? We're always going to give you our opinion. Okay? We're always going to do it. Agree with us, disagree with us, but we owe you our opinion. $50,000. The first 2 weeks in Grady Hospital. We're going to talk about that. This is a 2-slide one because there's a lot to unpack here. What is it worth to lay immobile and in pain, not being able to do anything for yourself while people operate on you multiple times over a 2-week period? What is that worth? Just that horror. And, we try to think how to explain to you through testimony what that was like, but there's really no way. I mean, we can show you photographs that she's just stuck, unable to move. We can show you videos of her and, wailing and agonizing pain. But what's misleading about that is you only hear that for about 30 seconds, right? But that was her life for 2 weeks, okay? That was her life for 2 weeks. We value that at $20,000 a day or $280,000. By the way, as I say, we included that, the surgeries to her right arm, her right wrist, both bones in her left arm, both bones in her right leg, her knee, and her ankle. And then we also include in it the second surgery on March 11th, while she was still in for that 2-week period, where they took this grotesque exterior rod off of her that she had been living with until then. That's how we get the $280,000. Second 2 weeks were spent at Emory DeKalb Hospital. Boy, that was a treat. She got shunted to the COVID ward. And, it's funny how quickly memories fade, right? We're so used to the fact that really today, COVID, I guess, is a slight concern. And we got to be aware of it. We have our boosters, and if we need to travel, right, we can take a test. It takes an hour, I think, and they tell you whether you're positive or not for COVID. That wasn't the case back in March of 2020. Back then, COVID test took 3 days. They shunted her off. She was supposed to be there for 2 weeks to start learning how to, feed herself, right? Walking wasn't even in the cards, all right? They weren't even going to try to teach her how to walk there. That wasn't on the agenda. It was, can you use your hands well enough to maybe grasp a cup, right? That is what they were hoping to help her with during that 2 weeks. Instead, what happened was, because of all the pain she was in, her temperature went up. A nurse saw that, went out of the room, changed into a hazmat suit, came back, and then sent her down to the COVID ward. And during this whole 2 week period, unlike the period of Grady, she wasn't allowed to have family come visit her. She was all alone when all of this happened. She didn't have her families there saying, listen, it's gonna be all right, we're with you, we'll stay with you, we'll make it all right. She didn't have that. She was completely isolated. Nevertheless, they didn't do 6 surgeries on her or whatever while she was in Henry DeKalb. So we didn't ask for as much daily money. It was still awful, but there was no surgeries involved, right? At least there was that. We value those days at $10,000 a day, or $140,000 is what MARTA owes Ms. Daniels for putting her there for 2 weeks. Let's talk about this. Learning how to. And the word learning sounds kind of fun, right? Kind of challenging. We all love to learn. Learning's great, learning's fun. But not all learning's fun though, right? Learning when you're so immobile that you can't walk, you can't really move your arms, but working as hard as you can with 2 people assisting you to finally be able to get into a wheelchair. And then, you saw the very first video of that. And what I loved about that video wasn't that it showed how hard it was, again, for Ms. Daniels to accomplish that even with assistance. My favorite part of that video is when she said, yeah, you're not going to keep me down. That's who she was. I love that. It was revealing, She had to learn how to walk again. And we showed you video of that, but the video again, it just gives you just this little glimpse of it, right? It just shows you a couple little moments in time, but you can look at it and imagine how painful, how frustrating, and how just difficult that was. And she couldn't walk for months. And then when she learned how to walk, it took months. We showed you an earlier video for a rehab in Texas, which when she was trying to learn to take a few labored steps while being in a harness. And then we showed you a clip from a month later, when she's still in a harness a month later, but she can slowly in a harness walk with a cane. And by the way, all these videos that we showed you are going to be available to you as you deliberate. She had to learn how to eat again with hands like this, with a wrist that was fused. She had to learn how to dress herself without using her right wrist. Just picture that a little bit, if you will, in your mind. That was something. The self-hygiene thing, to me, is worth more than all this combined, but we didn't do that. $25,000 for not being able to go to the bathroom by yourself, by having somebody else have to do that for you. These are the numbers we think are fair. And these are categories that we think are fair, and that's what's important. March 2nd, 2020 through September 19, 2022, which was Monday, was 931 days. 931 days. So what I'm talking to you about now is what MARTA owes for those 931 days. Not talking about day 932 through the rest of her life, day 0 through day 931. Scarring. The scarring is awful, and I don't have to tell you, you saw it. It's going to be with her forever. She testified that she thinks about it constantly. And why wouldn't she? She sees it every time she either looks down at her feet or glances at her arms. She sees it. And not only does she feel bad because she's got the scars, but then it reminds her why she has the scars. Scars are insidious because they're a reminder of how you got them. And she was somebody who took pride in the way she presented herself. We think that $3.35 an hour for those first 931 days is fair for living with the scarring that she testified to. Now, how do I get to my number? $3.35 per hour, self-explanatory. And then you see in parentheses 16 hours per day. That's because we're generally awake 16 hours a day. And it's not fair to charge MARTA anything, right, for an hour when she's sleeping. That's not fair. So $3.35 an hour for 16 hours a day. That's how we get our numbers. As I told you, any number we give you, we're going to do our best to explain what it means. Legs that swell and hurt every day. She has lived, as she told you, not in intermittent pain, but in total, constant, unremitting pain since this happened. And a huge part of that has been the pain and swelling in her legs. Also her ankles, but first we're going to talk about her knee and her legs. She walked when she could walk, before she had a fugue, with her right foot pointed out and her left knee pointed in, okay? And just imagine if your leg were twisted that way and you had to walk on it, and that was the only leg you could walk on. What would that be like? What would it feel like? What would it feel like at the end of the day when you walked on it as much as you had to for any given day? We think that that pain is worth $25 an hour. We don't think that a company could pay somebody $25 an hour to endure that, which is one way you could look at it. We don't think you could find anybody who would take that job at $25 a day. But $25 a day times 16 hours, excuse me, $25 an hour times 16 hours a day, $372,400. Right ankle fusion, that's the surgery. That's not the forever consequences of the surgery. We're going to talk about that later. But for having to be told by a doctor, the only way to stop your unrelenting ankle pain is for me to fuse two bones together in your ankle, and then think about that happening, and then having to have a surgery, and then having to recover from the surgery. And as you can see, she's still not done. We're in the middle of that. A right ankle that swells and hurts every day. Please keep in mind when we say that her right ankle swells and hurt her every day, that's just not us saying that. It hurt her so bad every day that she was willing to have a doctor fuse her ankle. Okay, there was no other reason to fuse the ankle. It wasn't medically necessary to keep her ankle attached to her leg or anything. It was because the pain was so bad that she'd rather have her ankle fused than live with the pain. Okay, that's objectively true. MARTA won't deny it. That's why she had the ankle surgery. For that pain, $450 a day. She didn't have that before. She didn't deserve that. She had to suffer with that. They have to pay her for that. We value that at $28.13 an hour for a 16-hour day, which is $450 a day. 4 times 931 days, $418,950. Frozen wrist. There are just too many too many consequences of having a wrist you can't move for me to sit here and list them all for you. I mean, I could just spend, fortunately for you, I will not, I could spend the rest of the day talking about things that are different in your life if you can't move your wrist. Can't lift heavy things, harder to dress yourself. If you have to use a walker like this, you can just use your right fingers to support one side of the walker while you put all your weight on your left, because you can't mash down because she doesn't have any strength in her fused wrist anymore. There's a million things, not to mention just knowing, just seeing your wrist and knowing that it can't move. It's just awful. We value that at $500 a day. That is what we think that MARTA owes her for taking away the use of the right wrist. That's $31 an hour and 25 cents. $465,500. We didn't assign money to this. I just wanted to point it out. You can take it into account how you will. She's had to live, Miss Daniels led a very stable life before this happened. She had the same job for years. She raised her family. They didn't move around. They weren't, globetrotters. But since MARTA hit her with a bus, she's had to stay in Grady Hospital, Emory DeKalb Hospital, her mom's house, her sister's house, her dad's house, her apartment where she used to work at Vineyards Drive, and back to her mom's house. And we don't know where she goes after that. Just keep that in mind. That was something that wasn't part of her life before. Now we go to future damages, okay? And this is the largest part of her case. This is the biggest part. And so let me tell you, before I talk to you about numbers, let me just talk to you about what we mean by future damages, because I think it's going to be important for MARTA when they get back up. Future damages means damages for the rest of your life. We're sending you, the judge is sending you back with mortality tables that you can use to determine how long somebody might probably live. The law, as the judge is going to read you, though, is that you can make your own determination about that. We believe that the fair number is 35 years. That would put her at 80 years old when she passes away. God willing, she'll live to 90, but she could die earlier. You have to pick the most likely age to value any permanent injury through. Because by definition, a permanent injury is something you owe for every day somebody is still alive and awake. So we have used 35 years. If you disagree with 35 years, substitute whatever number of years you believe is fair. 35 years comes to 204,400 waking hours. That is how many hours of being awake Miss Daniels likely has left on this earth. So, for any injury or damage that is permanent, she's entitled to money from MARTA for all 204,400 of those hours. The reason that Ms. Arnold can mock a large number at the end of the case is because she's counting on you thinking of that large number for basically what has already happened and what's maybe going to happen in the next year. But that's not fair, is it? If she's going to be alive for 204,400 hours for the rest of her life, if she has a permanent injury, whatever you determine that to be, you have to figure out what is she owed for an hour of that permanency, whatever it is. What is she owed for an hour? And whatever she's owed for an hour of it, if it's permanent, she's owed for all 204,400 hours. So that's how we've done our math. Living with a frozen right wrist, we valued that at $25 an hour. She's going to live for the rest of her life with a frozen wrist. Oh, and going back to the blame of the victim thing, well, MARTA doesn't owe that, right? They don't owe that because she didn't have another surgery. The first two surgeries were completely unsuccessful in allowing her motion in her wrist, right? But, you know, and wrist surgeries have got to be incredibly uncertain based on the fact that the first two didn't solve the problem. And so she is elected not to have a no guarantees third surgery. That doesn't mean they don't go for the fused wrist. That's a legitimate choice to make. That's a choice I think a lot of people would make. Don't blame the victim. She's got a fused wrist. MARTA did it to her. Let's talk about what it's worth. We think $25 an hour is fair. We think that, again, placed an ad in the paper for somebody who agreed to live not 9 to 5, not for the summer, but for the rest of their lives with a fused wrist. What would you have to pay them? Right? We think $25 an hour is modest. But the thing is, and what upsets MARTA, I think, is that if you take $25 an hour as fair, but then you multiply it times the number of hours she has left, you get kind of a large number, $5.110 million, right? But that's because she's going to have that for all of those hours. And so she's entitled to payment for all of those hours. Same with living with a fused right ankle. We don't think that the fused right ankle, in our opinion, based on the evidence, is as bad as the fused right wrist. I think the fused right wrist is awful. And I think that the fused ankle is problematic. And I think it is something that's real. I think it's going to prevent her from being stable. I think if she ever tried to wear high heels, for example, and couldn't rock her ankle left or right, she is asking to fall and break her leg again. I think that she could feel some screws poking out as well, which are painful and uncomfortable. Doesn't sound like that's going away. She said she mentioned it to the doctor. But she's never going to have an ankle that's unfused again. So whatever it's worth, and we all have to agree that it's worth something to have a fused ankle that doesn't work the way your old ankle did. If we can agree that that is worth something and that it will be forever, whatever that's worth, we have to figure out by the hour and then multiply times 204,400. And that's what we've done here. We didn't think it was worth as much as a wrist. We think maybe you'd have to pay somebody $15 an hour maybe to live the rest of their lives with a subpalmar ankle fusion. Not as much as you'd have to pay them to live with a fused right wrist. That's how we got our number. Living with permanent scarring all over the body. This is one of those things that I guess is different for everybody, right? Maybe a professional wrestler living with scars all over his body for the next 35 years, probably not so bad. Professional football player, probably not so bad. But for a woman like Ms. Daniels, it is bad. And the scarring is bad. And the scarring isn't just bad where other people can see it, and she's aware of that. It's bad where she can see it. And so that makes her think about it. And we think that's real. We think that has a value. And we think for Ms. Daniels, it's fair to value that at $5 an hour for living with a scarred body. We don't think that's unreasonable. If you do, pick another number. But we can't deny that she's going to live with scarring for the rest of her life. We cannot deny that because she is. So we just have to decide what that's worth, right? She's got at least 2 more surgeries to go. She may have more. The doctor that fused her ankle said he won't know whether there's a union there of the bones for 6 to 9 months. He said if there's not a union, she's going to have another ankle surgery, but hopefully there will be. And MARTA assures you that she'll be just fine from that surgery, so I guess don't worry about it. But for sure, she's going to have a total right knee replacement. And then 20 years after that, she's going to have some other kind of knee surgery. We didn't place a dollar value on these. We can leave that to you. You can decide what's fair. We'll accept whatever you think. But it's not a permanent future injury. See, it's a different category. So that's damages that are going to occur in the future, but they don't last forever, right? They're just discrete things that are going to happen for which she's entitled to money. whatever you decide that's worth, we'll be comfortable with. Living with fear and uncertainty. This goes back to what I was saying before. Who bears the risk of Ms. Daniels' future? Who bears that risk? Does Ms. Daniels have to bear the risk that things may go wrong in the future? Or does MARTA have to bear that risk? Somebody has to bear it. We can't ignore that question, right? Somebody is going to have to accept responsibility for that risk of things going wrong in the future. Because it exists, the risk exists. So somebody is gonna, either MARTA's gonna have to pay for that, or by not paying Ms. Daniels, she's gonna have to pay for that. We think since they caused the uncertainty, they should have to pay for the uncertainty. That's how we feel about it. Fear of her body breaking down, being hit again, she testified about that. Bad possible ankle fusion outcome, bad knee replacement outcome, bad second knee replacement. Fear that with all of this, she may have pain later in life that nobody can do anything about. These are things in her head for which she's entitled to money. We value that at $5 an hour. If you disagree, place a different value, but it's real, it has to be valued. Somebody's got to pay for it, whatever it's worth. So let's add up numbers. I told you we would justify our perspective on every number that we asked for. Medical expenses, $909,000. Economic losses, $916,000. Past damages, that was adding up. All of those numbers I gave you for the first 31 days? Yeah, sure. Every element of those damages I gave you adds up to $2,121,850. In other words, if God came down from heaven and restored Ms. Daniels to her prior self this very moment, we would ask you for her past general pain and suffering damages, $2,121,000. We would say that's fair for what she went through. Thank God she doesn't have anything to deal with in the future. But that's what they owe her for what they've done so far. That's what that number means. The next number is all future damages. That was taking all of the things that are likely or certain to be with her for the rest of her life, determining what's fair to pay somebody an hour for living with all of those things. And then once you come up with a number that's fair to pay somebody for living with all of the things that will be with her forever, you then multiply that times the number of hours she'll be awake before she dies. That's how we get our number. It's not a big number because we place a huge value on a small discrete period of time. We're not doing that. We place a pretty modest value on a small period of time. We're just letting you know she's got a lot of time left. She's got 35 years left. And so you've got to account for that. And that's how we got our numbers. I told you, you can agree with us, you can disagree with us, but I promised you we would justify what we're asking for, and that's how we done it. What? Well, this makes Ms. Daniels rich. This is kind of the subtext here of Marty's argument. Well, let's just make her rich. Even if it's fair, even if you agree with our logic, right? But won't this make her rich? And how do we feel about that? Even if the numbers are right, but if it ends up when you do the numbers right, what won't that make her rich? No, it won't. This is the funny thing. This doesn't make Ms. Daniels rich. Ms. Daniels was already rich. She was rich before she got hit by the MARTA bus. She was worth every penny of that because she had a completely working body and she had a career that she was proud of and that she was succeeding in. She had children that she knew we're proud of. She had an incredibly valuable life. This money doesn't add anything to Ms. Daniels. It's just that if MARTA takes away the value of her life in various categories, they have to replace it, and the only way they can replace it is with money. There's just no other way under our system. This doesn't make her rich. This wreck made her poor. It made her poor. It cost her unimaginable pain, unimaginable fear, unimaginable work, unimaginable loss. It made her poor. It made her that poor. It made her $15 million poor, is what it did. That $15 million doesn't make her $15 million richer. It just equates to giving her her life back from before this wreck happened. Now, I have a little example up here just to remind me to tell you this. We have done our best to explain to you why we're asking for what we're asking for. We've done our best. Here's what we'd ask of you. When MARTA gives you their number, however they justify it, sure they have a way. Even if they throw out a number like $3.2 million, which they'll try to, I would imagine, sell you as some sort of, life-changing money from Ms. Daniels. I want you to apply this formula to it. The same formula that we apply. Take her money, whatever MARTA says, subtract from it the medical bills, subtract from it however much you want to award for economic damages. We say $916,000, and see what you have left after that, okay? In this example, if MARTA tried to sell you on $3.2 million, and if you agree with our economic loss, she'd have $1,375,000 left after paying the hard costs, right? Wages and medical. So now you've got to apply of that $1,375,000. You've got to apply something, part of it, for the first 931 days, for all the harm that we've gone through, that we placed numbers on. We valued that period of time. I think it's about $2 million. You've got the number, but around $2 million. There's not even $2 million left here. So let's say you put $1 million of that, of your remaining 1.375 on her past losses. That gives you $375,000 for the rest of her life, for 204,400 weight gain hours. So if you wanted to know what MARTA values her lifetime future damages at, all you have to do is take 375,000 and divide it by the number of hours she has left. That would be $1.83. That's what they think you'd have to pay somebody to live with what Ms. Daniels is going to have to live with for the rest of their lives with no vacations. $1.83. I'll explain to you why she's owed what she's owed, but let me just say, the reason I think we're here is that MARTA believes that the reason they put up no evidence is they believe, they just simply have faith that there's no way a jury would ever actually give a woman like Jame Daniels complete compensation. They're just counting on that. That's why we're here. I hope they're wrong. I hope if I've got anything to stand in the way of explaining to you Ms. Daniels' case, that you'll put it on me and not on Ms. Daniels. She doesn't deserve any more happening to her than has already. We really appreciate it and we look forward to hearing from you. And by the way, may I just say, of course, I don't get to stand back up again. Let me just remind you of that. The law is I have to sit down, and no matter how angry I get, and you can tell I'm somebody who's passionate about this thing, I can't stand up and say a word about what Ms. Arnold says. I can't say a word. Okay? Please don't let the last thing you hear dominate your thinking. If you would just please remember that just because I can't stand up and point out all of the problems that I hear, doesn't mean that they're not there. It just means I'm not allowed. Okay? You'll give Ms. Daniels more fair consideration. If you will listen to the judge, you will follow the law that the judge gives you. We're comfortable with coming to the right verdict here. Thank you so much.
Thank you, Mr. Johnson. Ladies and gentlemen, we're going to take our morning break right now. That'll give Mr. Johnson a chance to get his board down, and Ms. Arnold can get set up, whatever she wants to get set up. We've got one more piece of closing arguments, the rebuttal, as they sometimes call it, from MARTA. Then I'll give you the law that you are to receive in this case, and you'll be off and running. So enjoy your break. Don't talk about the case yet. We'll see you in a few minutes. All right, Mr. Johnson, anything before we break?
No, Judge.
Ms. Arnold?
No, Judge.
All right, let's be back a little before 10:40 on the clock on the wall. Thanks. Oh, not 10:40, 10:50. Yeah, you guys have 4 seconds. Don't go far. Sorry, 10:50. Thank you. Ah, man. Don't want me on that jury.
Sorry. Sharon, could you put me for a call? No, I'm gonna take that down. I'll be busted. Take that down.
Can I go ahead and grab that clipper from you?
Yes.
I don't forget it.
Yes, absolutely.
Gosh, you have to tell us, Steve. Let's do that.
All right, last night.
Sure.
Judge,
Is in there, is that the only place where there's coffee in there with the jurors, or is there anywhere else in this building?
I think the 7th floor of the other building, you can get across, there's a sky bridge, and go down one. That's the big jury assembly room. It may have a machine that sells coffee, but don't quote me on that. I'm not a coffee guy.
Yeah, she gave me to go to her folks out, maybe.
Yeah, I think your best way to get caffeine in your system is through cold carbonated beverages. But I do think there's a coffee machine where you can buy coffee in that if someone goes across to the 7th floor to the jury room.
That's like the coffee.
Just don't bring her anything.
Yeah.
And the cup is very thin, you gonna burn your.
Well, there you go. Ms. Brown says,
What's the early morning activity, sport activity before school?
It is, what it is free Chick-fil-A breakfast with friends is really what it is, but it's called Bible study. He'd never gone before. He's at Westminster, and so it's technically a religious school.
Yeah.
There,
I know,
I love that
I
school.
just didn't bring that up earlier.
No.
So it's a new thing. He just started middle school and all his friends are doing it. And so he had his first one. I said, so how was it? What'd you learn? He's like, it's so cool. The high schoolers, because these high schoolers lead it. So it's big kids leading the little kids. I said, how about the Bible part? He's like, it was some psalm. We talked about it for 3 minutes. We talked about it for 3 minutes and then we talked about fantasy football. And I got chocolate milk and a chicken biscuit.
That is so cool.
It's
So-
there
so
with the high
you
school
weren't getting
kids.
up early.
For him,
Yeah.
I was less enthusiastic, but I'm happy that he's happy and he's engaging. And they, got mild exposure to a psalm. That's not going to hurt him. It's so early. And I'm the one who does the early driving. So that'll be my new Tuesday routine. The dogs don't get up early. They don't like it, but he's happy. So thank you for asking.
Here's a great way to learn about God.
I don't know how much of that was happening.
I think it was like 3 minutes. But
Yeah.
You got you 3 minutes in, so.
He'll get more exposure in, I think later in middle school and definitely as a freshman, a whole semester on Old Testament and a whole semester on New Testament. Which we've learned that the power play is to do it as summer school because then you can use that semester to take an elective like coding instead. So, all right, we've got everyone we need. Can you see? Well, I guess I'm just going to declare that. Well, hold on, Ms. Arnold, are you ready to go?
Yes, Your Honor.
Great. Let's bring the jurors in, please.
Rouse observed.
Is that the same board or a different board?
It's the same board, Your Honor.
Okay. Just in case they forgot from this morning. Thank you, Deputy Gordon. Welcome back, ladies and gentlemen. We are now going to receive from Ms. Arnold, MARTA's second half of their closing argument. When Ms. Arnold is done, I will give you what we call the charge of the court or the jury charge, AKA the law. When you're ready, Ms. Arnold.
Okay. Hello again, everybody. So Mr. Johnson made a bold promise in opening that he reminded you about just now in his closing. We are never going to ask you for a number we cannot support. And he came up here and he did just that. Because there is nothing about the number he suggested that is based in the law or the facts. First, let's talk about the slides. And I didn't count the slides, but I think there was 19 categories that he assigned some number to, right, that we looked at. That's not consistent with the law. The judge is going to tell you that pain and suffering is one category of damages that you will award, not 19 categories of damages. He mentioned some of the things that you're to consider when awarding pain and suffering as one category of damages. But these are factors to be considered. They're not separate categories. That is not consistent with the law, folks. Pain and suffering is one category of damages. So while you can consider what he mentioned, the factors as the law instructs, and the law will instruct you what those factors are, and we'll talk about those. That's what you're to consider. The charge that the law will give you has 7 factors in this charge. 7, not 19. Is that fair? Is that reasonable? It certainly isn't the law. The verdict form in this case is going to have 1 blank on it, not 19. This isn't the law. It's a trial strategy. Just like the other ones I mentioned when I came up here and talked to you earlier this morning. Because guess what? The more blanks that you add up and the more numbers that you add up, the higher the total award. And of course, he wants to throw out random numbers. Of course he does, because he doesn't want to focus on the other evidence in the case. And you, as the triers of fact, need to consider all the evidence in the case. Not random numbers that Mr. Johnson has chosen to assign to 19 categories that he believes should be considered under the law as damages. That is not the law, folks. So let's refocus on what is the law. And the judge will instruct you on what is the law. And the judge will instruct you on the recoverable categories of damages. And that includes medical expenses, past loss earnings, future loss earnings, and pain and suffering. And he will charge you about each of those. And you'll hear about these 7, or it might be even 6, factors that you can consider when determining that one number for pain and suffering. That is the law. You'll have to determine what's a fair and appropriate amount for each. And as I said in opening, and I'll say it again, damages must be reasonable and just. They must be reasonable, and they must be grounded in the evidence. A damages award that is not consistent with the law is not reasonable and just. $15 million is not reasonable and just. It's not consistent with the law as the judge will instruct you. We're going to talk about a number that would be fair and just, reasonable and just. But first, I want to talk about how the facts apply to the law on which you'll be charged, and why the facts do not support an award of $15 million in this case, which, like I said, it's more than double what I thought he was going to ask for. Now, I want to remind you what I told you in opening statements, because the judge is going to remind you when he charges you that although it's natural to feel sympathy for Ms. Daniels and what she's been through, because we all feel sympathy, that's natural, you cannot decide this case based on sympathy. You've got to view the evidence objectively and make a decision based on the law and the facts. And that's important to remember. $15 million is not consistent with the law and the facts. We are not contesting, as I said from the start, that Ms. Daniels has sustained significant injuries. I know that she's got to live with these scars. I know that she's dealt with a lot of pain, and she's still dealing with pain, and she's got a road ahead of her. We're not disputing that. That's why we're writing a check for at least $1 million for the meds. We don't contest that. We don't contest that there is going to be an award for pain and suffering. We want you to get an award for pain and suffering, but the law is that it must be reasonable and just. That's what kind of award you need to give for pain and suffering. I want you to look at these 6 factors, and it is 6, not 7. 6 factors that the judge is going to charge you that you can consider when coming up with your one number for pain and suffering. And everything that Mr. Johnson talked about is encompassed within these factors that you consider when determining what your fair and reasonable award is for pain and suffering. But I want you also to be thinking about the evidence in this case, the evidence that supports these 3 key points that are going to help you decide this case. Because that's the rest of the evidence that you have to consider when coming up with that one category of damages, that one number. The activities she's still able to do on a daily basis. The trips she's able to take. The things she's able to enjoy. The surgeries that are expected to eliminate the pain in her lower extremities. And let me just take a minute to say, Mr. Johnson now claims that these projections, I think he used the word miracle. He's choosing not to believe the doctors. Well, I'm pretty sure when we preserve these doctors' testimony for trial, that you heard him ask the question, Doctor, have your opinions been given to a reasonable degree of medical certainty? And they all said, absolutely. Now Mr. Johnson wants to choose not to believe the doctors who have testified to a medical degree of reasonable certainty. I choose to believe the doctors who have testified to a reasonable degree of medical certainty about their projections for Ms. Daniels. And that if she continues with her path of treatment, with the emphasis on the rehabilitation, that she should be able to achieve her goals. And you heard him say there's no reason we expect her not to be able to achieve these goals. So why are we doubting that? Why is Ms. Daniels' attorney doubting that? Other positive evidence in this case. The fact that she'll be able to, if these surgeries are successful, as everyone expects, wear normal shoes again, maybe even high heels, you heard Dr. Sadlak say. And you heard how important it is to Ms. Daniels to get dressed up and get her hair done and look like a lady and wear these fun, funky shoes. That is a goal for her. We're celebrating that. That's what these doctors are hoping and planning for with these surgeries. So don't forget about that when you're considering what goes into this number. The fact that she, according to her own experts, will return to work next September. And Mr. Johnson acts like it's MARTA saying she's going to go back to work. Remember, that's an opinion from his own expert. I didn't put that evidence in the case. That is his own expert. And that's a positive thing. The fact that she may return to work sooner or at a higher pay than what Dr. Seaman has estimated for her. That's something for you to consider. The fact that she may return to her prior job. That's something for you to consider. The fact that, as awful as it was, post-COVID life has provided us with many opportunities, employment opportunities, with work from home options, flexible schedules which may help accommodate her as she gradually re-enters the workforce, as she continues her path to recovery. That's a positive thing to consider. And all that evidence you can consider when coming up with that one number for that one category of damages. Those are all things to consider. And that's the number we're talking about here, because the meds and the lost earnings, those are hard numbers, and those are cap numbers, and we're going to talk about that. You heard a lot from Ms. Daniels about the things she's able to do. And like I said when I got up here earlier this morning, as she should, as we want her to do, we want her to live her life. We want her to move forward. And we're here and we're trying to help that happen. We are here to make that happen. And we're here to pay a fair and reasonable award to do that. Why isn't Mr. Johnson focused on her capabilities? Why is he focused on her inabilities? Why is he focused on the past rather than the future? Again, we're not disputing everything she's been through. I know she's been through hell, and she's still going through a lot, and we acknowledge that. But he's not telling you, he's not talking about the other positive things that allow her to continue with some aspects of normal living, to allow her to continue with some enjoyment of life. Things that go into the full picture, all the evidence that go into the picture when you are deciding what that number will be. So as you're considering all of those other aspects that need to go into the decision for what you award for pain and suffering, we need to talk about mitigation. Because the judge is going to instruct you that a person who is injured by another has a duty to mitigate. They have a duty to mitigate their damages as much as reasonably practical, right? We're not asking for anything more than what is reasonably practical. And that's what the law says. The law says you have a duty to mitigate, that the plaintiff is obligated to reduce those damages as much as practical, and this includes following the reasonable instructions and advice of her doctors. So let's talk about what that means with respect to the right wrist. Because you heard Dr. Payne testify emphatically about the need to be working with a certified hand therapist and what those specific exercises were and how long she needed to be doing that therapy and why that was so important to restore her range of motion and her strength in her wrist. Did you hear any evidence that Ms. Daniels actually did those things? She was going to PT in Texas, but her last three visits were in September, October, November, once a month. She agreed. The last visit said, continue the plan of care. She came back to Atlanta. She opted out. Those were her words. She opted out of any further treatment for the wrist. That was her decision, not ours. So consider that when you are determining pain and suffering and limitations that she claims with respect to the wrist. You also heard Ms. Daniels testify that she hasn't made any attempts to look for work in the past 2.5 years. And we're going to give you, there's a range. There's a cap. If you believe their evidence that their expert says, if she hadn't gone back to work from the day one all the way to September 2023, that's $245,000. And we'll talk about that. And I'm going to use that number. I'm going to use that number because that's the cap, right? That's assuming she has not been able to do any work since the accident and going forward into next year. But you can decide to give a number lower than that. But we're going to use that in our calculation when we get there. That brings me back to what's fair and reasonable compensation for Ms. Daniels. And we need to consider that question against our 3 key points, which I keep bringing back, because again, these reflect the evidence in the case. These will help you determine the case. And we believe that the numbers we submit are supported by these points, which are grounded in the evidence. So let's talk through these categories of damages, right? Past medical treatment, like I said, we've bought that, right? We owe that. We are writing a check for that. We're not asking for a discount off this number, which I've rounded up to $910,000. We're not asking for a discount. Put it on the tab. We know we owe that. Future meds, the only evidence you've heard in this case is Dr. Sadlack with respect to the future knee surgery. And he capped that somewhere between $12,000 and $40,000. So future meds, less than or equal to $40,000, according to Dr. Sadlack. Past loss earnings, I just told you, the cap is 245. Dr. Seaman says if she assumes she hasn't been able to go back to any form of employment since the day of this accident, up through September 2023, that's the number. And that's the max number if you believe everything the plaintiff has told you. Just like the meds, that's the max number if you believe everything they've told you. The future medical treatment, the max if you believe everything they've told you. Those are the numbers we're putting up here. They could be less. You could choose for them to be less. I'm telling you what the max is. Loss of household services, less than or equal to 46,000, rounded up. You heard Dr. Seaman, those terminate next September when she goes back to work at some form of job. Now, I'm gonna go back to lost earnings because Mr. Johnson said or suggested that it would have been Ms. Friedman's opinion that Ms. News could have gone back to work as a property manager. You know that's not her opinion. Dr. Seaman relied on her opinion, which was that she could work in a sedentary capacity. And that's not, according to the testimony I've heard, what they believe this job to have been. That wasn't her opinion. So we're not hiding that. Their own expert relied on it. Future loss earnings. Again, the ceiling, according to the plaintiff's own expert, $698,000, including the fringe benefits. That's his number. If you believe everything the plaintiff has said, if you believe that she's only able to go back to work as of September 2023 in a sedentary job, that's the max. Could be less. She goes back to work sooner. She goes back to work at a higher paying job. If she goes back to work at her exact same job, drops to zero. That's up to you. That's up to you. So if you believe all of the plaintiff's evidence, you get a number just under 2 million, but let's round it up to 2. If you don't believe all the plaintiff's evidence and you believe she could have or should have mitigated against some of those economic damages, then your number will be lower. But again, that's up to you. So what does that leave? That leaves the category of damages we started talking about, pain and suffering, which is the hardest category to measure. I think I said that in opening. But as I also told you in opening, any category of damages, including pain and suffering, must be fair, reasonable, and grounded in the evidence. We would respectfully submit to you that an amount between $500,000 and $1 million is fair, reasonable, and grounded in the evidence. And let's talk about why. Let's talk about how this amount of money could have a real and meaningful impact on Miss Daniel's life, on her life and her family's life. Because you heard her say, her life is for kids. So let's think about what she could do with that kind of money. You heard her testify. Her son dropped out of college. Let's put her son back in college. Help him finish college. Her daughter wants to go on college tours. She said she's had to put that on hold. Let's pay for the college tours. Let's pay for the college tuition. Let's get her daughter through college. Real, meaningful impact with the money we're talking about. Family is something that's very important to her. You heard her mom say she planned get-togethers for the family. What could you do with this kind of money with your friends and your family? How many nights out to eat? How many parties at mama's house? How many going to the movies? How many trips to New Orleans? Savings. Money is something that she stresses about. Let's put some money in savings. Let's put some money in an investment where she has an income stream that she could live off, that would reduce that stress. Let's put some money in retirement. Real meaningful impact with this kind of money. She's concerned about making the rent. Let's buy her a house. Buy her a house, she never has to worry about rent again. That's the kind of impact this kind of money will have. Travel. We know she likes to do it. How many more trips could this kind of money pay for? With friends, with her kids, with family. We want to help her keep doing the things that she loves. And that's what this kind of money will do. Hair and nails. Now, Mr. Johnson seemed to discount those. But you know what? Those things are important to Ms. Daniels because they make her feel good about herself. Just like getting dressed up, putting on fun shoes, made her feel good about herself. Those are important things to Ms. Daniels. How many pedicures could she get with this kind of money? She could get back to get her hair done every 2 weeks. We know that's important to her. She would sleep on her arm. I still don't know how she does it, but she would do it. And that's important to her. And that's why we've considered it, because this kind of money can provide those things for her, which are important to her. Real meaningful impact. You didn't hear Mr. Johnson talk about things like this. You heard Mr. Johnson assign numbers to 19 factors that he chose to have you value for pain and suffering. And folks, we're talking about the other side of the coin, the other things you've got to consider for pain and suffering. Like I said, you're the triers of fact. You need to hear all the evidence. You need to consider all the evidence. And that's my job, to make sure you've got it all, so that you can make a fair and reasonable decision. So adding our pain and suffering award, and that's a bracket, to the special damages that the plaintiff, that's if you believe every word that came out of Mr. Johnson's mouth, you believe every word that came out of the plaintiff's witnesses, $2 million, add that to our pain and suffering, and that's $2.5 to $3 million. Some of you may think 3 million is way too much. Some of you may be thinking 2.5 is too little. But that's up to you. It's up to you to determine what is fair and reasonable based on the facts and the law. We submit that this range of damages is fair and reasonable and grounded in the law. And it's supported by our 3 key points, which are born out of the evidence in this case. That's what this case is about. Not sympathy or emotion or anger. It's the facts and the law as reflected in these key points. And that's what's going to help you answer this question, which is the one question you're here to answer. What is fair and reasonable compensation for Ms. Daniels? So now I'm going to turn it over to you to do your job, a job that we thank you very much for, a job that is very important to our judicial system. And I'm going to let you do what you came here to do. It's been my honor to present this case to you on behalf of MARTA. And we thank you for your time. And we thank you for what you're doing for us in this case.
Do you guys mind getting the easel and board, please? All right, it's my turn. I don't get to stand up there in front of you all and pace around. I have to stay up here. But it is time for the jury charge, the law that you are about to receive that you must apply to the facts as you find them to be. A couple things about this charge before I dive into it. Number one, you're welcome to take notes as you have been throughout the trial. This document from which I will be reading will go back to the jury with you. So if I start getting into some legal mumbo jumbo, I don't know what he just said, I'm reading from this. So you'll have the language with you, which leads naturally into number two, about the legal mumbo jumbo. I do my best to make the legal instructions I give you accessible, as in I understand them and you understand them. There are certain legal terms that I am required by more powerful judges, Court of Appeals, Supreme Court, to define in a certain way. And so there may be some things I say to you, like, why is he talking to me like that? He doesn't need to impress me with the big words. And I'm not trying to, but I need to say things in certain ways so that none of us runs afoul of the higher court, should there be an appeal in this case. So I am trying to speak to you and not talk at you throughout this process. But if it gets a little stiff in its presentation, you'll have the document to try to decipher what I meant when I drop some big words in there. Procedurally, I'll be reading this to you so you can hear it, but I will also have on the big screen the words that I'm reading. Some people follow better if they can see it, others if they listen. Just stay awake, whether you are listening or watching or both. And again, you'll have the document with you during your deliberations. With that, ladies and gentlemen, you have been considering the case of Jame Daniels versus MARTA. This suit stems from a motor vehicle collision that occurred on March 2, 2020 in Atlanta at around 12:35 p.m. Plaintiff was driving alone in her car headed west on Cleveland Avenue when a MARTA bus traveling east swerved into Plaintiff's lane, striking her 2016 Nissan Altima. As a result of this collision, Plaintiff was injured and underwent multiple surgeries. MARTA admits fault responsibility for this accident. It further admits that Plaintiff was injured because of the collision. MARTA disputes only the amount of damages Plaintiff is seeking. That was all facts, not law. But that narrative that I shared with you, you may accept as true without any further proof, because we've moved past that and are talking now about what are those damages for which MARTA may be liable. This you heard before. This is the burden of proof. Let me make that smaller. The plaintiff must prove her case by what is known as a preponderance of the evidence. That is, evidence that is sufficient to incline a reasonable and impartial mind to one side of the issue rather than the other. Remember me talking to you about the scales. The scales leaning ever so perceptibly in one direction. If neither party proves its case by a preponderance, in other words, if you find that the scales are exactly balanced on a particular question, the size of these damages or those, your verdict would be in favor of defendant without a money recovery for anyone as to that item of damages. Evidence is the means by which a fact is established or disproved. Evidence in this case includes all the witness testimony and the exhibits that were admitted. It does not include opening statements or closing arguments, any questions that were asked, or anything else the attorneys or I have said. Now, during trial, you were permitted to submit questions. They're all here. The answers to those questions are evidence. You should draw no conclusion or inference from the fact that some of your questions were not asked. Questions are not evidence, only the answers from the witnesses are. In considering the evidence that you have received, you are free to use reasoning and common sense to make deductions and reach conclusions. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I saw the bus hit the car. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. I was inside the library, I heard some skidding, I heard a big crash sound, and I looked out the window and it looked like there had been an accident. You could pull together from those circumstantial facts that something else happened. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. You should not be concerned about whether the evidence you received was direct or circumstantial. You must, as part of your job back there in the deliberation room, determine the credibility or believability of the witnesses from whom you've heard. In doing so, you may consider all the facts of the case, the witness's manner of testifying, the probability or improbability of the testimony, and their interest or lack of interest in the outcome of this case. In determining credibility, you may consider evidence offered to attack a witness's credibility. This can include evidence of a prior inconsistent statement or a bias for or against a party to this lawsuit. Credibility may also be attacked by disproving facts to which a witness testified. In determining the credibility of a witness whose credibility has been attacked, you may consider evidence offered to support the credibility of the witness. Testimony has been given by witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not familiar to the average person. Expert witnesses may give their opinions based on that training and experience. However, testimony of an expert, like that of all witnesses, is to be given only the weight and credit you think it should receive. Damages. Damages are given as compensation for any injury sustained from a tort. A tort is an act that causes injury to another. The defendant has admitted that it committed the tort, i.e. the accident, in this case. You must decide whether the accident caused any damages to plaintiff. When one party is required to pay damages to another, the law seeks to ensure that the damages awarded are fair to both parties. If you believe that plaintiff is entitled to recover, you should award the plaintiff only the amount you believe is reasonable and just in this case. The plaintiff bears the burden of proof with respect to damages. She must prove each of the damages with reasonable certainty. You may not award any damages to plaintiff which are speculative or based upon mere guesswork. When a person is injured by the negligence of another, when a tort occurs, she must mitigate her damages as much as is practicable by the use of ordinary care and diligence. If you find that plaintiff has suffered damages, she is obligated to reduce those damages as much as is practicable by the use of ordinary care. This includes following the reasonable instructions and advice of her doctors. If you believe that by the use of ordinary care, plaintiff could have reduced her damages, you should determine to what extent and reduce those damages accordingly. Necessary expenses resulting from injuries caused by a tort, the accident in this case, are a legitimate item of damages. As to medical expenses, such as hospital, doctor, and medicine bills, the amount of damages would be the reasonable value of reasonably necessary expenses. Loss of earnings from the time of the alleged injury, the accident, to the time of trial is a legal item of damages, and its measure is the value of the earnings that the evidence shows with reasonable certainty plaintiff has lost as a result of her injuries. You may consider what plaintiff was earning at the time of her injuries, what she has earned since her injuries, and the amount customarily paid in this area for the kind of work plaintiff does. There must be some evidence as to plaintiff's loss of earnings for you to award this type of damages. You may not speculate. If you find that plaintiff's earnings will be permanently reduced, lost future earnings are to be determined on the basis of the earnings that plaintiff will lose in the future. As with past earnings, there must be some evidence as to the amount of her future potential earnings. In assessing the evidence, you may consider that old age generally reduces the capacity to labor and earn money. You may also consider that plaintiff's ability to earn money could have increased during later periods of her life, if the evidence supports such a notion. You may determine the plaintiff's life expectancy solely from her age. In deciding this, you may consider evidence pertaining to her health, habits, and surroundings. Another way in which you may determine plaintiff's life expectancy is to consider what we call a mortality table. And you have in evidence two mortality tables. I think they're P40 and 41. Numbers don't matter. You'll find them. They're in there. One of them is called the Commissioner's 1958 Standard Ordinary Mortality Table. The other is called the Annuity Mortality Table for 1949. Life expectancy shown on any such table is merely a guide that you may follow to determine life expectancy. Pain and suffering is another legal item of damages. The measure is the enlightened conscience of fair and impartial jurors. That would be one of those legal phrases I mentioned. It's the enlightened conscience of fair and impartial jurors. Questions of whether, how much, and how long plaintiff has suffered or will suffer are for you to decide. In evaluating plaintiff's pain and suffering, you may consider the following factors, if proven. 1, interference with normal living. 2, interference with the enjoyment of life. 3, loss of capacity to labor and earn money. 4, impairment of bodily health and vigor. 5, actual pain and suffering, past and future. And 6, the extent to which plaintiff must now limit her activities. Ladies and gentlemen, by no ruling or comment, by anything I've said, have I meant to express an opinion about the credibility of witnesses, the evidence, or which party should prevail in this case. Whatever your verdict is in the case, it must be unanimous, meaning all of you agree to it, in writing, dated, and signed by your foreperson. And we accomplish that by having you all use this verdict form, which is in writing, and your foreperson will date it and sign it. Your verdict should be based upon your opinion of the evidence according to the laws given to you by me right now. You must consider the facts objectively, without favor, affection, or sympathy to any party. It's a long paragraph. Roll with me on this one. If you find for plaintiff, you must determine an amount to be awarded to her. That's the damages you award. The law requires that your verdict be unanimous. That is, agreed to by each of you after the amount is determined. It is improper to agree in advance to be bound by the figure, the amount that is calculated by each of you writing down what you think the right number is. Then you add it all up and divide by 12. Oh, there's our number. You may not agree in advance to do that. However, If you wish to use this method to arrive at an amount for discussion without binding yourself in advance to accept the result, you may do so. You are not prohibited from accepting that result, what we call a quotient verdict, hence the name of the slide. You are not prohibited from accepting that result and adopting it as your verdict after the amount is determined if you believe, from a preponderance of the evidence, that the figure arrived at by this method represents just and adequate damages. However, you must have first found in favor of defendant, and you must all agree that the amount represents your verdict after the amount has been determined. One of your first jobs in the deliberation room will be to select a foreperson who will preside over your deliberations and who will sign this verdict to which you all freely and voluntarily agree. The Post-it's going to go away. It reminds me to give you guys calculators while you're back there. Each of you, you should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your colleagues. This should come as no surprise. During your deliberations, you must not communicate with anyone outside your group about the case, nor may you conduct any outside research. You have all the evidence you're going to receive in this case, and it would be improper to supplement it with any outside information. And one way we ensure that is that before you begin your deliberations, Deputy Gordon will be collecting a nice little tray he brings in all of your electronic devices, including Apple Watches. Don't try to sneak one in. Again, to do your math, you'll have several calculators. So don't say, oh, I need to keep my phone to do some math. We'll give you calculators. That's all they do. They do not have internet access. I don't know if some of you know what a calculator is, but you're going to experience one in the jury room. During your deliberations, should you need to communicate with me for any reason, you've got a question, a concern, it needs to be in writing like you did with your questions. You can write it on a card. You can write it on one of the pages from your notepad, but write that question down because we need to make it part of the record. I will then confer with the lawyers and give you whatever answer I am allowed by law to give. Sometimes the answers are, you got to sort that one out yourself. And it's not me trying to be difficult, but sometimes legally, I'm not allowed to answer the very good question you have. It's one that 12 of you are going to need to sort out through your deliberations. But where I am authorized, I'll give you as comprehensive and hopefully helpful an answer as I can. The end. Before you retire to the jury room, Mr. Goss, you're going to stay out here while everyone goes back there, and we're going to talk to you individually for a moment. Then you're going to go back there. I need the rest of the 12 of you to go back to the jury room. Please don't start your deliberations until you get the jury charge and the verdict form and the evidence, the papers and one thumb drive that you're going to get. If you need to watch any of those videos again, just send a note saying we want to watch a video, and we'll bring you back out here. You're not going to be able, it's a thumb drive. So unless one of you has a real funky insert in your head, you're not going to be able to watch the videos in the jury room. But let us know if that's something you need to do. Once you get all that stuff, you can begin your deliberations, and you can, you can get to work. You'll break for lunch when you want to break for lunch. If you want to have a working lunch, that's fine, but all 12 of you have to be in the room while you're discussing the case. So you may decide, we're all going to leave for 20 minutes, grab food and bring it back. You may say, we want an hour off and we'll begin our deliberations when we get back. No deliberations with less than 12. Don't break into, hey, we're going to go in this room and 5 of us are going to talk about the case while the other 7 go get the pizza. I may have misspoken in giving the quotient verdict paragraph. It was so long. The last sentence reads, as you saw on the screen, it may not have been what came out my mouth. It also reads in the jury charge. To even think about a quotient verdict, you must first have found in favor of the plaintiff. If you find in favor of the defendant, you're not going to need to do a whole lot of math. And then the rest of the sentence stands as it was given. You all go with Deputy Gordon, please, except for Mr. Goss.
All right, reserve.
Mr. Goss, you are our alternate. And you're our alternate, not because you came late the first day, but just you were the last juror selected when we do jury selection. So it has been very important that you've been here. You have heard all the evidence in this case and a very effective argument from both sides. We're going to preserve that information you have by having you stay here for at least today while your colleagues are deliberating. If we finish today, they get a verdict, everyone will go home. If they don't finish today, then the lawyers and I will talk to you about maybe being on call tomorrow if you could get down here quickly enough. Because if we lose one of these 12, you will slot in as a deliberating juror. During this downtime, when they're deliberating, you get to keep your electronic devices if you brought any, so you can read or watch videos, do whatever you want to do, but don't research the case at all. We need to keep your bubble intact because you may well need to join 11 others if we have to excuse one of the 12. I think we're going to set you up in the room over there that has a little tornado drawn on it. That's another jury room, and that's usually where we put the alternate or alternates. But Deputy Gordon will get you a spot to be. I promise we won't forget about you. When they go to lunch, you can go to lunch, and you can go to lunch with them because no one can talk about the case when they're outside of the jury room. And if there is a verdict, you cannot be here while it's announced in case there's an issue with it. We need to send them back. But once that's over, we'll bring you out, get you back there and get you a letter that everyone else will get saying this is where you've been. Any questions about that? Okay, Deputy Gordon, you'll go with him. Well, you need to get your stuff. If you have stuff in the jury room, I don't know if you have any belongings in the jury room, you should collect that. If you got all your stuff, you're good to go. Otherwise, get what you need out of the jury room. Okay? You can barge on in. This is your room still. Mr. Johnson, any exceptions to the charge as given?
No.
Ms. Arnold?
There.
Okay. Have you all agreed that the stack of exhibits by Ms. Brown is the stack that ought to go back, or do we need to get anything on the record about some things not going back with the jury? Mr. Johnson?
We moved into evidence and the medical illustration, I believe it should go back with the jury. It was relied upon by the doctors in their video depositions. There's no reason that it should be treated any differently than the photographs.
Okay. If you all need a minute to go through the stack of things, people don't need to stay standing. But I want to make sure that what we've got there is the right universe. So why don't we I'm going to stay right out here to keep the pressure on, but why don't we have everyone go through the pile, make sure both sides are good with it, and then I'll hear from the defense about what P number is it, so we're clear in the record.
P35, Judge.
Okay.
Stack of views.
Me?
Okay. Ms. Arnold, what is your view about P35? The chart that was used with not all the doctors, but most of the doctors, and kind of in evidence.
I know there's a smaller, I think he's got it on a page, like a paper that would fit in that stack. I don't think it was attached to it.
I have a photocopy of it. I'm asking for the.
Okay, I'm going to allow P35 in its current size to go back. It is demonstrative. It also was something upon which several of the doctors repeatedly relied in answering questions from both sides. I don't think it's a continuing witness issue. I think it's appropriate for the jurors to be able to look at it as they're working through what they're working through. Any other concerns from plaintiff about what's going back?
I believe so, Judge.
Anything from defense?
No, Your Honor, as long as that is the poster, I think it is, not the other one.
Well, why don't we turn it around?
I can't show this to you. I'm sorry. No.
Just make sure it's not wrong with 19 categories. All right, thanks.
Okay, then I'll have Deputy Gordon bring that back along with the verdict form and the jury charge, and we're going to get them a couple calculators as well. I need a phone number from each side that we can call to ensure that a lawyer from each side returns when we need you back in court. You're welcome to stay in court. This day is all dedicated to this trial, but you may want to go out in the hallway, etc. So please get me the one phone number my team can call to get someone from plaintiff here and the one phone number for defense.
Yes.
You don't want 3 numbers. Okay.
I will dial only one. You can write down 10 numbers, but we will dial the first. Just give it to me.
I will now.
Yeah.
Jeff doesn't think I check my phone now.
No,
It
Okay.
must mean you check your phone too much.
that's, no, I said.
Ms. Brown, I'm going to give you, this is Court's Exhibit 1. Those are all the juror questions.
That's crazy. You're writing, hopefully you.
Got it.
All right.
Does the feed stay live?
I'm going to mute it and it will say jury deliberating. So the screen will say jury deliberating and I will mute that microphone so that what you say, there's one microphone that sends everything out. I'll take care of that. Don't press any of the buttons. I think that's it then. Ms. Brown, should we get a phone number for you or you're going to be hanging out here?
I can give my phone number. I'll probably between here and the.
Want to write it on there, please? Deputy Gordon, we are ready. It is this plus that stack of documents and that board. Yeah. And then Ms. Niles has some calculator.
Do they get that?
Oh, yeah, they do. Yeah, that too. That's just to remind them if they want to watch it, they need to let us know. Thank you.
That was that's the call about the baby.
You just got a call?
No, I'm just saying. I took his phone. No, I had
Yeah.
his wife the number to China.
Yes, she should call Chambers. So that's perfect. Thank you for thinking through that. I'm sure he helped you. C1, great.
So
I'm sorry?
Care that this is on YouTube. Scared.
Okay,
Well,
Record.
yeah, okay. We'll say something in a minute.
so we're back on. I just had to get the microphone working at the podium so that the audio is going out. Just a sec. So we are on the record, and I know there's something you want to talk about. I'm going to talk first. My understanding is that the jurors have a verdict, but we're going to talk before we bring the jury out. So Mr. Johnson.
We would ask that this discussion not be broadcast for confidentiality reasons.
Now you tell me. Okay.
Well, I tried to.
Not taken down on the record either?
No, taken down on the record, but not made public.
Got it. I'll mute things in just a moment. All right, so let me figure out how to undo it. All right, audio is back on. In other words, it's an open audio courtroom. It was always an open visual courtroom, so the lip readers know the secret. But otherwise, I think we're in a position to bring the jury in. Thank you.
All right, adjourn. All jurors are present.
Thank you, Deputy Gordon. You all can be seated. Welcome back, jurors. It's my understanding that you all have reached a verdict. Is that correct?
Yes.
Are you the foreperson? The verdict that was reached, was it a unanimous verdict?
It was.
And have you memorialized it in writing? Okay, and specifically you have as the foreperson?
I did.
Okay, can you hand that verdict to Deputy Gordon, please? All right, thank you. So, Ms. Clay, I'm going to ask you to rise and do what we call publish the verdict, which is read it into the record.
Yes, sir. Do you want me to read from where it says verdict down, or do you want me to read from the very top?
Verdict down.
Yes, sir. The verdict: we, the jury, find for the plaintiff in the amount of $5 million. So say we all, this the 21st day of September, 2022.
And you've signed it and printed your name on it.
Yes, sir.
Great, thank you so much. Deputy Gordon, if you'd get that verdict form to Mr. Johnson, please. Can you get Michelle back? Beautiful, thank you. Mr. Johnson, any objection to the form of the verdict?
No, Your Honor.
Ms. Arnold?
No, Your Honor.
Okay. Mr. Johnson, any reason I cannot release this jury?
No, Your Honor.
Ms. Arnold?
No, Your Honor.
Okay, ladies and gentlemen, before you run out of here, a couple things. I want to thank you on behalf of everyone involved. This was a very important matter for Ms. Daniels, obviously, and for MARTA as well. And it was something that they tried to resolve and were not able to resolve, and required members of our community to listen to what happened and figure out what ought to happen going forward. And that was your role, and you did a great job. Thank you for your time away from family and work and other pressing issues. In a moment, you're going to go back to the jury room. You'll be reunited with your devices. I'm going to come back and thank you, see if you have any questions or feedback as to how we could run trials better. We'll reunite you with your alternate as well, so you can let them know what happened. We have letters for any juror who needs, it's like a note for the teacher. If you need a letter that says, look, this is where this person was for the last 3 days, it will document where you were for employer or suspicious significant other, whatever it might be. And then that'll be it. So if you'll go with Deputy Gordon, I'll see you in the jury room in just a minute. Thank you. I'll give you this.
Yes.
We get those with another.
All right, Mr. Johnson, anything else from plaintiff?
No, I'll need to submit an order, I guess.
You will need to submit a proposed final judgment,
Yeah.
but draft that, share it with someone on the MARTA team, and then get it to Ms. Niles. And that'll be the final judgment and order in this case. Whether you want that to be coupled with the discussion we had, I leave it up to you, or that's a separate document. Happy signing 2 orders, but
I think it's two separate documents. It's the easy way to go there. Don't you think so?
Yeah.
Yeah.
send me what you choose to send me. And please send them in Word format to Ms. Niles, and I'll take it from there. Anything else, Ms. Arnold, from MARTA's side? Okay, we'll get the exhibits back from the jurors to be made part of the official record that the court reporter has put together. You all will make the court reporter whole, I trust, both sides, and you'll go from there. I want to thank everyone for your time and focus. This was very efficiently tried. I think the jurors appreciated that. I know I did. Ms. Daniels, I wish you the best going forward. This doesn't make things stop hurting, but it will help you navigate some of what you need to navigate. I wish you the best with that. And MARTA, I wish you the best in continuing to operate your trains and buses and trolley cars if we really have to do more trolley cars. I don't know if MARTA even has to do the trolley cars, but we'll see how that goes. All right, thank you, everyone.
Thank you,
Thank you,
Judge.
Judge.
Judge, I'll be remiss if I did not say that Bill Buhey says hello a lot. He literally has asked me every day.
We were like, we're not gonna tell him that.
I know.
You know him. He's being nice. to
Okay.
us.
Yeah, if I had known, oh my gosh,
Yeah.
how do we add another million to the verdict?
Since we're doing this, I've been asked to say hello after my wife, who's Michelle Johnson, and you put her up for the College of Labor and Employment Lawyers
Oh, yeah,
back in the day.
interesting.
At Nelson Mullins.
Okay.
So, anyway,
Excellent.
See.
It's all these intersections.
That's
Mis-
right.
Mr. Buhey, that's funny.
I can check them out where things need to go.
Yeah, I think Mr. Johnson provided them because they're originals and like old school. Now maybe they go in the docket, but talk with them. I'll take the letters and you can.
I don't know.
Oh, yeah.
It comes with the originals.
What now?
Were you asking about those?
Yes, they were in my chair.
So those were for filing.
In the Zoom.
We use them in, well, they were to be filed.
It's been in-
These are